The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain how to collect a debt. There's basically 4 steps. Step 1 is internal collection procedures. Step 2 is a demand letter. Step 3 is filing suit and obtaining a judgment. And step 4 is collecting on that judgment. At any stage in this process, the goal is to settle with the person you're trying to collect from. So having them pay you voluntarily, whether it's through a payment plan or a lump sum in full or in part. So ideally, we don't want to go through this whole process because that can take a lot of time and it can be somewhat expensive. But it's an escalation of pressure from step 1 to step 4 that causes most people to eventually, hopefully, pay you before getting to the end of the process. So step 1 is having good internal collection procedures. And this starts with a contract with your customers. If you're a business or if you're giving a loan to a friend, a good contract with that person. And that contract should have a couple provisions in it. First, you want to provide that if you need to collect on the debt, if they fail to pay you, that you are going to get your attorney's fees and court costs. And what this does is makes it economically feasible to pursue the debt because you're going to get your attorney's fees paid for ultimately if you're successful and they're not judgment proof, meaning they have no money whatsoever. The second thing you want to include is a late fee provision, providing for 9% late fees or something like that if payment is past due. This allows you to at least, while you're waiting for the debt to be paid, be making the equivalent of interest on it at a decent rate, and it encourages them to actually pay on time. So that's what goes into the contract. In your invoices you send out, if you're a business, you want to make sure you explain your collection procedures. So explain on the face of the invoice in bold that if the debt becomes 30 days or more past due, they're gonna start receiving late fees. If it becomes 90 days past due, it's sent to your collection attorney. We like to make it not personalized. This is just our procedure. The customer has no reason to get mad at you for it. It's just how you manage your accounts receivable. Once it gets to 90 days past due, you may want to extend a final warning letter to them before sending it to your collection attorney. But that's the point where you want to send it to your collection attorney as quickly as possible, because the longer a debt goes unpaid, the less a chance of you ever seeing the money for it. So you don't want to hold off on that once you get to the 90-day mark. Once it goes to your collection attorney, the first thing they'll do is send a demand letter. And if someone receives a demand letter on attorney stationery threatening suit to collect the debt, this is often much more persuasive than just an invoice from the company that they contracted with. The next phase after the demand letter, we usually would give 30 days to pay or the lawsuit will be initiated, is you actually have to obtain a judgment against them for the debt. So this is filing a complaint and summons in the appropriate court. If it's a small amount, you go to small claims court if it's less than $10,000. If it's above $10,000, it's not small claims court, but small claims court is an expedited process. Either way, the person who owes the debt rarely shows up in court, and what will happen if they don't show up and they've been properly served with summons is a default judgment will be entered in your favor on that first court date for the amount of the debt plus any attorney's fees and court costs, assuming that you have that in your contract, and any late fees and interest on the debt from the date that it was accrued. So now you've got your judgment. The next step is collecting on that judgment, because the judgment is just a piece of paper. So you have to find out what assets the person has and have the court order them turned over to you if they're not willing to pay on the judgment voluntarily. So we do this through something called a citation to discover assets. This is something that, again, is personally served on the person who owes you money. It also goes to their banks if we can locate their banks. And the citation will freeze any accounts that they have. So basically, they won't be able to access their bank account once the citation is served upon their bank. And what a citation is it's another summons to appear in court to testify as to the assets that they have and to provide certain documentation. And your attorney will look over the documentation, ask them questions, and see if they have any collectible assets. If they do have any collectible assets, the court will issue a turnover order ordering those assets turned over to you. If it's in a bank account, the turnover order will go straight to the bank, and the bank will pay you to satisfy your debt. If the person doesn't have enough assets to satisfy the debt, you can renew the citation periodically. Check in with them, have them come into court every 6 months or every year to see if their situation has changed. If they have a job, you can have their employer withhold their wages as well. This is called a wage garnishment. If they fail to appear in court on the citation, there's basically an escalating procedure where the court will hold them in contempt. They'll have a second court date where they can appear and show why they shouldn't be held in contempt. And basically, if they appear and then testify, they won't be held in contempt. But eventually, they may be held in contempt of court, and a warrant will be issued for their arrest if they fail to appear at this citation proceeding once it escalates to that point. But this may require 2 or 3 court dates before the warrant is actually issued, because you have to basically go through the whole contempt proceeding through this rule to show cause that has to be served on them. They have to fail to appear at the rule to show cause why they shouldn't be held in contempt. And if they do fail to appear, that's when something called a body attachment is issued. And if they're picked over, they're stopped for speeding, they'll actually be taken into jail. And then the citation proceeding will be held before they're released from jail, or they'll have to pay a bond and agree to appear at the new court date that's set. So that's, again, you don't want to go through that whole procedure. That's as far as it can possibly go. The idea is to have the debt settled before it gets to the collection procedure, before it escalates all the way to a citation to discover assets. You want them to voluntarily pay, but this is how pressure is increased from internal collections all the way to a lawsuit. And hopefully they pay or come up with a payment plan or settle with a lump sum in full or in part before that point. So if you have any questions, please leave us a comment below the post at learn-about-law.com or below our YouTube video, and we'll try to answer them within 24 hours. If you found this helpful, please subscribe to us on YouTube, iTunes, or SoundCloud. And if you'd like, please feel free to call us for a free consultation at 630-324-6666. That's 630-324-6666. We offer free consultations in nearly every area of law, and we have 6 offices throughout Chicagoland for your convenience. Thanks so much for listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.